Hello, and welcome to this Know Your Rights presentation for the Glenview Public Library. My name is Ken Willer, and I'm an immigration attorney with the North Suburban Legal Aid Clinic. Today's presentation will be in three parts: a quick introduction about who we are and immigration law in the U.S., followed by the three main areas where you may encounter immigration enforcement, and we'll discuss what your rights are in each of those areas. And lastly, we'll discuss immigration law and policy updates in the last few months. A quick note, please be advised that this presentation is being recorded in March of 2026. And if you are watching this in the future, some of these updates may have already changed. If you have any questions or would like to discuss your immigration situation with us, our contact information will be displayed at the end of this presentation. So once again, my name is Ken Willer. I'm an immigration attorney with the North Suburban Legal Aid Clinic. Our clinic is located in Highland Park. Our mission is stated here that we provide accessible, quality, pro bono legal services in the area of immigration, domestic violence, and housing to give those in need of access to justice the opportunity to live productive and secure lives. As a quick note, if you have questions or know somebody who also may have questions about domestic violence or housing, we do have two separate teams with attorneys who do practice in those areas. And once again, our contact information will be stated at the end of this presentation. Okay, so going to U.S. immigration law. Our immigration law is very complicated, and there are many, many agencies that help to enforce and apply the law, most of which are at the federal level. Almost everything listed here, as you can tell, is at the federal level and not the state level. Additionally, you may notice that these agencies are mostly executive agencies that work at the behest of the executive branch, the White House or the president, instead of, for example, Congress. I do want to point your attention to the Executive Office of Immigration Review, the fourth line from the bottom there. That is known as EOIR, but it's more commonly known as Immigration Court. So we will be discussing what goes on there later in this presentation, but Immigration Court is obviously very important to our practice and to many people right now. Unlike many other courts, such as the federal courts that are listed lower, these work once more at the executive level, run by the White House rather than by the Constitution's setup of the federal courts. What this means is that immigration court does not run by the same exact rules as other courts may have to follow, such as the federal rules of civil procedure. This typically means that the rules are slightly different, and in some cases, some protections are not guaranteed. Most importantly, the right to counsel is protected in immigration court, but it is not guaranteed. You will not have an attorney provided to you if you are in immigration court. And as we go further down from EOIR, you'll see the Board of Immigration Appeals, the federal court system, the federal appellate courts, and the U.S. Supreme Courts. Those are the typical routes that one would take if they have to appeal their case. So once again, this presentation is about know your rights. What are your rights if you do encounter immigration enforcement? What can you do? What can't you do? And we break this down into three distinct areas. So typically we think of public areas, the workplace, and a private home. We'll start in public areas. Pretty easy to think of what a public area is. A park, walking down the street typically is public. And so the rules here are, well, I'm going to repeat many of these rules for each of these slides, but typically we always advise people not to lie if they're ever asked questions by anybody, not to carry false documentation, and if they are presented with documents, they do not have to sign anything. The Fourth Amendment of the U.S. Constitution applies in all of these areas, and the Fourth Amendment, just like all the rules of the Constitution, do apply to anybody in the jurisdiction of the United States, and that means basically anybody who is in the United States has the same protections that the Constitution confers to them, regardless of immigration status. So the Fourth Amendment typically means that law enforcement cannot detain or arrest somebody unless there is probable cause or a warrant for their arrest. So in this case, again, you can only really legally be detained or arrested if there is a warrant for your arrest, or an enforcement officer observes you committing something that may be probable cause of a crime or a violation. So for immigration, what does probable cause mean? It can mean many things. Running away is the biggest one. So if someone runs away, if they see a large group of, for example, ICE or CBP agents, and they run away, that can be probable cause to stop and detain them and ask about their immigration status. That is in our example here. If there's an ICE raid at a business, ICE sees you running away from the business, that is enough to legally stop that person and ask about their situation. Okay, ICE encounters at work. Obviously, everybody's workplace is a little different. Typically, there's two main things to think about when it comes to workplaces. One, what are your private areas and your public areas? So I like to think of a restaurant as a very typical breakdown of these two areas. Obviously, anyone can go into the front of a restaurant when it's open, right? And they can walk around. However, you wouldn't normally walk into a restaurant and just go straight to the kitchen or the back area, right? That would be uncomfortable at best and probably not allowed in most places. So typically, ICE agents can go, or immigration enforcement agents can go to a work site without warning, and they can enter those public spaces just as though they were a public park or any other area like that. Once again, the rules that we advise our advisors are the same in the situation. Do not lie, do not carry false documents, and don't sign anything if you're presented that. Again, running away from a building can be probable cause. But the big takeaway when it comes to ICE encounters at work is if you do have private areas, mark them plainly. If you're, the employer or you work there, think about adding in signage that says employees only or private, no authorized personnel beyond this point. That will help clearly delineate, clearly separate what areas are for the general public and what are not. And we'll talk about how to be an ally toward the end of this presentation too, but one other area when it comes to work to think about is making sure everybody who works at the site knows these rules, right? So if, for example, you have a receptionist, they need to know what the plan is if really any law enforcement comes to the office. Like, will there be someone to call? Will they ensure that everybody stays in the front? It's important to discuss these things before they happen. Lastly, ICE encounters at home. From a constitutional standpoint, the home is generally considered the most private of spaces, and for that reason, most people do have the most protections there. So the main thing, this is similar to the same as if this was involving law enforcement, not immigration enforcement. But if somebody knocks on your door and says they're the police or immigration enforcement, you typically do not have to answer, you don't have to open that door unless they come with a signed warrant, and that signed warrant is signed by a judge. So we'll go through our advisals like usual, right? So do not lie, do not say you're someone else, do not have documentation that is false or from someone else on you. And if you are asked to sign something, again, do not sign it. You can wait to sign until you are advised by an attorney what you're signing. But once again, if you're at a house and somebody says they'd like to come in, you do not have to open that door unless they say we have a warrant for this person at this location at this time. So we'll go and discuss what these warrants may look like if this happens at a home. There are two types of warrants. The judicial warrant on the left here is the really important one. That's the one that can lawfully allow enforcement to come into a home. And the one on the right is called an administrative warrant. That is not signed by a judge. It is signed typically by an ICE agent themselves. That is a warrant for somebody's arrest, but it cannot be used. It could be used in public. It could not be used to enter a home, for example. Now, in real life, if ICE is at your door, the first thing you want to do is, again, ask for a warrant. They will typically provide the warrant, either slide it under the door or through the mail slot, whatever may work. You do typically have the opportunity to review that warrant. So our advice is read the warrant. I know it's a stressful time, obviously, but you do have the right to read that warrant. Check to make sure that it's for the right address, that the information's all correct, right? So if it's for somebody who doesn't live there, or if it's somebody with the name incorrect or the incorrect address, you can send it back and say that person's not here, this is not correct. And typically, in our experience, ICE, generally, if they don't get it right, they will try to come back and get it right the next time. But it is important, right? So you do have that right to review the warrant. Otherwise, again, you have the right to refuse entry to enforcement. Okay. So what should someone do if someone around you is arrested or detained? First, there is an ICE locator. This website, locator.ice.gov, it will eventually help you locate where this person has been taken to. Typically, if someone is arrested in the Chicago area, they are sent to the Broadview ICE facility for at least one day. But those people do not stay at Broadview for very long. They're typically moved out of state to other ICE detention facilities. The slide says, there are no ICE detention facilities in Illinois, so typically people are moved out of Broadview very quickly. And the best way to find out where they are is by using that website. Secondly, we advise that if you are a family or friend of somebody who has been detained, to first call the family support hotline that is listed on the screen here. Again, that will help them hopefully get facts very quickly so that they can help arrange representation if possible. We will mention that for certain people, it says here ICE detention at ISAP check-ins. ISAP is for people who are technically, it's considered intensive supervision by ICE or CBP. Those are people who typically have monitors on their ankles, and instead of being detained, they are monitored electronically and told to regularly check in at ICE locations. We have seen in the last year or so that ICE has now been at those those check-ins and have detained people there as well. But again, our advice is contact an attorney, an immigration attorney, as soon as you can. There are methods to hopefully get someone released, but they're not easy and they're not quick. So as you see here, if they're in immigration court, they may be able to ask for bond so that they can be released. If they are in detention, they may be eligible for a federal habeas petition as well, which essentially claims that there's no lawful reason for this person to be detained under the Constitution and they must be released. So now we're getting more into our updates over the last year or so about immigration. So last summer, the Big Beautiful Act was passed into law. It provided a very large sum of money for immigration enforcement. As you see here, $170 billion for the next 4 years to hire more personnel and just generally more resources for immigration enforcement. As we know, last fall there was Operation Midway Blitz, which sent in many more ICE agents into the area and conducted more immigration raids. In the past few months, Operation Midway Blitz has ended. There may be another surge in enforcement in the following months. We don't know. But that does not mean that ICE has left our area in any way, shape, or form. There's always a permanent ICE presence in our area. And as we said, they do sometimes detain people at their check-ins. They may, in some rare cases, also even detain people at USCIS interviews. USCIS is the main immigration agency in the US Citizenship and Immigration Services. Most people who are doing interviews at USCIS are typically not detainable or removable from the US. So it is concerning that there have been reports that ICE sometimes detain people at USCIS. It recently came out that there was a May 2025 memo to ICE and ICE agents that essentially argued that ICE agents may enter a home without a valid judicial warrant. That, again, on its face, does sound like a strong violation of the Fourth Amendment. And this is why, again, when I mentioned that updates may change, it's very important to stay up to date on these things because while the government may argue one thing, once it goes to litigation, you never know what the status of one policy is or not. Continuing on, ICE has been detaining and deporting U and T visa applicants who have had deferred action or pending applications. So U's and T visas are typically for people who are victims of violent crimes in the US or trafficking in the US. Deferred action, generally speaking, is a promise from the government that somebody who has deferred action will not be removed from the country unless they commit serious crimes. But again, we have heard of stories where people with deferred action have been detained and in some cases deported even with deferred action. We see here over 70% of detainees have not had any criminal convictions or warrants for their arrests. There have been many more detentions in the last year than before. Voluntary departure. So when we talk about not signing forms, oftentimes those forms are consent for voluntary departure. Essentially, that means that a non-citizen agrees to leave the country, but those have serious consequences for future applications in the US. And that's why, again, our advice is always to review this with an attorney before signing anything. But we have, again, heard and seen of the government putting coercion, duress, and lies to get people to sign voluntary departure forms. And in some cases, people have been removed to their native country without due process in a very quick fashion. I will mention that while some people have been removed very quickly once they're detained, that's not always the case. Even people who are detained and want to leave detention, want to go back to their native countries quickly, that's not always the case. That can still take weeks, if not months. So there is no one typical situation for somebody who is detained by immigration. Okay, so in the first Trump administration, the travel bans were attempted, challenged in courts, and the Trump administration ultimately found a way that essentially stuck with the courts. So the travel bans are back in this administration, and they've been applied to even more countries now. And once again, as of this recording, there's a whole different state of different travel bans. So it does depend on the country and what somebody from that country may be applying for. I'm not going to list all of these countries, but it is a large number. Again, if you or someone you know is from one of these countries, it doesn't necessarily mean that it's impossible to come to the US or to get status in the US. It simply means that you have to strongly advise speaking with an attorney first to see what you want and whether it's possible. But generally speaking, again, the list of countries has grown in the last few months. Going back to USCIS, US Citizenship and Immigration Services, they've also been slowly changing their policies, generally to make it more difficult to get approvals in applications. So Going back to that list of countries, USCIS also has a list of countries now where they may pause or severely slow the processing of cases from people from certain countries. So we have here, asylum applications. Adjudications have been paused regardless of countries since December. Refugees are essentially asylum applicants, but they start their process before coming to the U.S. Refugee and asylum status very generally is for people who have a fear of persecution in their home country based on certain categories. It's very difficult to earn asylum or refugee status, but again, it's been even more difficult for these people to either come to the U.S. or stay in the U.S. During this administration. Naturalization interviews and oath ceremonies have been canceled for certain individuals. Naturalization is essentially a word for citizenship. It's the last stage for many immigrants in the U.S. And typically it's most vetting and legal work, the legal processes usually are done by that stage, by the oath ceremony. But once again, USCIS is now holding that back for certain people. I talked about deferred action on the last slide. Once again, deferred action is essentially, it's not a status, it's just a promise that while you have deferred action, unless you commit a crime in the US, the government will not try to remove you or deport you from the country. And on this slide, we're talking about special immigrant juveniles. Those are people under either 18 or 21 who have been adjudicated by a court, and that court has held that either one or both of their parents has abandoned, abused, or neglected them. There is a method of relief for immigration available to those people. It does take many years, and typically they do receive deferred action while they wait for their visa. Now, again, in the last few months, they have not been getting deferred action once they apply. The Violence Against Women Act is also, it's a very large law, but it does have an immigration component as well. So those who apply for VAWA relief for immigration typically were married to a U.S. citizen or are married to a U.S. citizen. They suffered extreme abuse or suffering. And USCIS now recently has made the criteria for that even more difficult to earn that status. So going now to EOIR and the BIA, once again, EOIR is immigration court. The BIA is the next appellate level to immigration court. What's going on there is this term called pretermission. Pretermission essentially is really a motion to cancel any proceedings against somebody and essentially hold them removable without even hearing the basis for their claim. So most people in asylum court most people in immigration court, excuse me, have applied for asylum. There's usually 2 court dates in immigration court, the second being the full evidentiary hearing. And now the US government is attempting to not even have that evidentiary hearing held, essentially by making, and one of the excuses would be that the person hasn't paid their fee. This fee, by the way, is brand new. It just started last year. Typically, asylees are not asked to pay a fee to apply because they don't have work authorization. They typically don't have very much money, but now there is both an application fee and an annual fee that an asylum applicant must pay. There are other bases for claiming pretermission, whether it be claiming that their application wasn't filled out completely, or there are other bases as well. We've seen the Trump administration, the first one, also tried to broaden what we call third-party agreements. The idea is that many asylees, the basis of asylum is that someone can't return to their native country because they fear persecution. So now the Trump administration is trying to find other countries that will accept these people where arguably they would be safe, but not in the US. These are very controversial for many reasons, obviously, that we're sending people who don't have any status or desire to enter to be in these countries. But as you can see, Guatemala, Honduras, Ecuador, and Uganda have those agreements, and then Costa Rica, El Salvador, South Sudan also can be one of these third-party countries. These motions to pre-term it are very popular right now. I will say that again, this changes from month to month. They have been very popular in the past few months, but we have reason to believe they may not be as popular anymore. But again, the whole idea is to move cases through immigration court, whether or not someone's case is heard. So again, immigration court, it's limiting the options that somebody in removal proceedings may have. There is a current case called Maldonado Bautista that argues that immigration judges are not following the rules of the law as it applies to people who are detained, whether or not certain individuals have the right to a bond hearing and be released or not. That is, again, still in litigation. Again, there have been also attempts to limit what qualifies for asylum. So we have here, it says bad case law by BIA to limit asylum PSGs. Essentially, those are some of the categories that somebody may have a successful asylum claim. For example, it gets very specific, but people from certain countries who experience domestic violence, they may have had successful asylum claims in the past, but those are now being limited. And there are more challenges to what somebody would consider good moral character as well. Temporary protected status is not immigration court. That's actually back to USCIS. Very briefly, temporary protected status is it is a status that is allowed for by the Department of State in cases where a country has experienced either natural disaster or warfare, and there is a reason why certain people, nationals from those countries, cannot return home. So typically, we saw that for Venezuela, we saw that for Ukraine. It does not provide, TPS, as it's known, temporary protected status, does not provide a pathway to citizenship, but it simply provides status so that people do not get removed from the country. They have lawful status here. The administration has really attempted to limit or end most of those programs. Freedom of Information Act requests. These are known as FOIAs. Every government agency at every level has freedom of information requests that they must allow by law. The idea being that if somebody it believes that they have their own personal information at a government agency, they can ask to review what is there. But we have seen that in the last year or so, these requests have been really difficult to get responses to at this point, both in terms of timing and just in terms of rejections at the first request. So what that leads to is litigating. You have to go to court, explain that the government's not following the law, and demand relief. Okay, so going back to people who are concerned about immigration, either they are immigrants themselves or maybe they have friends and family who are. These are our advisals, basically, our tips. Always have an emergency contact. Be able to know how to call them without using just your cell phone. Just make sure you know their phone number so that you can call them without looking it up. If you have an A number, A numbers they're known as alien numbers. Those are the numbers that anybody who's had contact with immigration or applied for something with immigration, you most likely have an A number. Make sure you know it and make sure that your emergency contact also knows that. That's very important because, for example, the ICE locator, it works a lot better in most cases if you know what that person's A number is. If you have children in school, make sure that they always ask for emergency contact numbers, but make sure you also have that contact of yours that they have the authority to take your kid if necessary as well. Speaking of children, short-term guardianships, we'll talk about that on the next slide, but those can provide a lot of peace of mind for parents who are worried about being detained or removed from the country. Always make sure you have your important documents in one area and make sure someone else knows where they are. So passports, civil documents like birth certificates, marriage certificates. If you have immigration paperwork, make sure you have them all in one location. Even better if you have them scanned in somewhere, maybe on a Google Drive as well, so that everybody has a copy and can pull them up quickly. If you take important medications, make sure that your emergency contact knows that as well. Again, keep that all in the same place. And lastly, if you have children, please discuss your immigration status with them and let them be part of the safety plan as well. Short-term guardianships. So the idea of the short-term guardianship, it doesn't have to be just for immigration status, for immigration matters. It can be for really any situation where a parent may be incapacitated or unable to take care of their child. The idea is that someone can fill out this short-term guardianship letter, essentially designating someone else to take care of their child for up to a year once they no longer take care of them. The nice part about these letters are they do not require you to go to a judge. You don't have to even file it with a government agency. You really just have to fill out a 2-page form, keep a copy with you, keep a copy with the guardian, and if ever it does need to take place, again, the 1 year starts from when it's needed. So you can keep it for 5 years, and then if something unfortunately happens, that 1 year starts from the triggering event. I will say for guardians, we do always, strongly recommend that the guardians must be at least 18 years old. They should not have a criminal record, and ideally they should be U.S. citizens as well. If you have questions about these short-term guardianships, please contact our office. We often have workshops for them. And lastly, know your legal rights. So we always recommend that if you are an immigrant, please get a legal review done by, if not us, there are plenty of other organizations that provide either free or low-cost consultations. If you spoke to an attorney a few years ago, it might be a good idea to go again. Again, things do change in immigration. And it's always best to make sure that you're not missing out on something. If you are a victim of a crime in the US, again, you may be eligible for relief. It depends. People who flee persecution in their home country may seek asylum in the US. Minors who were abandoned, neglected, or abused by at least one parent may qualify for special immigrant juvenile status. Victims of trafficking or domestic violence. And then most commonly, people who have immediate family members who are either US citizens or who have a green card, what's known as lawful permanent status, may be eligible for relief as well. Again, it really depends, and there's really no great way to do it without speaking to a qualified attorney first. As I mentioned earlier in this presentation, you do have the right to hire an attorney if you are in removal proceedings at immigration court, but there is no way for the government to provide you one. So you may have an attorney, but you will not be given one. You can't be forced to sign an immigration document you don't understand. So once again, if you are presented with papers, it is perfectly fine to say, I'm not signing anything until I have an attorney explain it to me. If you are charged with a crime outside of immigration, if you're charged with a crime, please remember that as a non-citizen, there may be immigration consequences to anything you do in a criminal court. So sometimes even criminal attorneys are not fully aware of the consequences for immigration to, for example, pleading a case down. So if you are an immigrant and you do have criminal charges against you, please consider discussing with an immigration attorney as well as your criminal attorney before making decisions on that case. If you already have convictions, criminal convictions, please remember that getting those convictions expunged or unsealed or sealed, that does not necessarily mean you can hide or not discuss those convictions later on with immigration. Immigration will still consider those to be crimes and convictions. And honestly, if you get them expunged or sealed, they may be even more difficult to obtain the documents you will need to prove to immigration court that the case is closed. Again, no matter what your immigration status is, you always have the right to remain silent. You don't have to answer questions if approached by ICE. And pay attention to trusted news sources. As we probably all know by now, obviously the news is very fast. Everything happens very quickly these days. But that also means that it's these stories, especially related to immigration, can be ripe for abuse by people who like to post quickly before thinking about what the actual facts of the situation were. So that goes into how to be an ally. If you do see immigration enforcement actions, you do have the right to film, of course, in public spaces. This, of course, use common sense. If you're in a bathroom or anywhere else that seems private, please think about that before you record. Please remember, if you do record something, please remember to use only facts. Think about where you're posting if you're posting, because again, we don't want to start with rumors that may have been slightly untrue. That's what starts a lot of other issues. Keep your distance away from immigration agents. We've seen all the news in the last few months about detentions and threats of detentions for people who do film. Of course, again, it is legal to film in public, but the line between filming and impeding can be very difficult, especially in the heat of the moment. And protect the detainee's privacy, especially if there are children around. Please remember, again, you may be filming people you don't know, and you don't know their situation either. And if you are close enough to the detained person, consider getting their information if you can get their name. See if you can help contact whoever their contact person is, because we don't know. Again, it may be an hour or two at the very least before they can contact somebody. So it's always that can be very helpful. So yes. And that's it for this presentation. Again, if you have any questions or if you'd like to have a consultation, our contact information is here. Leah Kim is our Director of Immigration. We're open Monday through Friday, 9 a.m. to 5. We have plenty of languages we speak on staff, and we can always find interpretation if you fall outside of our list of languages. And again, our phone number is 847-737-4042. I want to thank the Glenview Public Library for this opportunity. And once again, this is recorded in March of 2026. If you have questions, and if it's been a while, please remember that things may have changed. But thank you again for your time.